Mr. Nishit Ranjan Chaki. Mr. Nishit Ranjan Chaki is an assistant professor of law at KCC Institute of Legal and Higher Education. This institute is affiliated to Guru Govind Singh Indraprastha University, Delhi, NCR, Greater Noida.
Namaste, everyone. So I have been given the topic of impact of 10th schedule on the coalition politics in India. So as our very respected last speaker Vinay sir has told about the origins of the coalition politics and what are the practical effects of this coalition politics, and he has also highlighted that what are the two sides of the coalition politics, why it is good and why it is also facing the problem of defection. Now I'll take the cue from his last observations about freedom of speech and expression, sir. And you have told about Article 19 and also the right of political dissent. And with that, I'll be trying to deal with the topic from the right of political dissent and from the right of from the issue of defection in Indian politics. So a very interesting thing that I would first like to refer is that Winston Churchill was also a defector. So he was elected in the Conservative Party and he moved to the Liberal side. And even after, just imagine that even after winning the Second World War, he lost the elections, the general elections. So when we talk about democracy or when we talk about voting behavior, when we talk about political behavior, theories can be given. Theories have been given by eminent scholars, but people tend to vote on more on emotions also. Emotions play a large factor, and the connection with the local leader that play a large factor. Now, interestingly, when the Anti-Defection Law, as we know it today, the 10th schedule, that is 52nd Constitutional Amendment Act was passed, the then Congress government was having a huge majority, and there was not even a single vote against this constitutional amendment. So I'm talking about 1985. There was not even a single vote against this constitutional amendment. So it shows the unanimity that everyone was agreeing to this to the passage of this anti-defection law, because as sir has already highlighted, after the fourth general elections from 1967 to 73, there has been a widespread defection, and since the colloquial term that is being told about this defection is Ayaram Garam, it also has its origin during those days. Now, what is important to understand in this entire defection politics is that there is an interplay between the national political parties, the parties that hold power in the nation, in the country level, and the political parties that are holding power or having their stronghold in the states. So, in this case, defection, I think, is also an issue of federation, of designing the political federation of our country, and it is also a issue of heterogeneity of Indian population. On the negative side, defection, why it is required to nip the bud of this problem of political defection is that it will create unstable governments. The thing is that the right of freedom of speech and expression and the right of political dissent, that is okay. But when we talk about defection, the primary argument that is taken when we want to curb the evil of defection is that it creates unstable governments. Not only that, it creates what is known as the devaluation of the constitutional functionaries. For example, the chief minister's post, it devalues the chief minister's post, or even the prime minister's post in some cases, because we have seen in history that some defectors went on to become the chief minister, went on to become ministers, and went on to become prime ministers also. Now, when we talk about 10th schedule of the constitution, it is to be remembered that the 10th schedule is to be read with other provisions of the constitution, which are Article 103, Article 74, Article 101 and 102, and Article 122 and 212. So, taking from the starting, if I say about the origin of the 10th schedule, the Constitution, 32nd Amendment Act, and the 48th Amendment Act, not act, the bill was, it was tried to pass a bill, the Constitution 32nd Amendment Bill and 48th Amendment Bill in 1973 and 79 respectively, it failed. After that, we have the 52nd Amendment Act 1985. Now, when we have introduced this 57th Amendment Act 1985, it recognized the concept of split, right? Under paragraph 3 of the 10th schedule, there was a concept of split that if you are having a dissent with your own political party, you can go and split that political party if you are having a certain number of requisites, member of parliament or member of legislative assembly. And after that, through the 170th report of the Law Commission 1999, the Goswami Committee report, the National Commission on the Review of the Working of the Constitution report under 2002, it was found that the provision of split was being, it was being misused by the legislatures. They were hiding under the cloak of split when they actually wanted to defect from the party, right? So whenever there is a very thin line of division between this freedom of speech or expression and right of political dissent and the outright defection generally happens only on cases of personal motives. If you have a lure for the constitutional office, if you want to become the minister, if you want to have some financial consideration on the part of your defection, on the part of your political behavior, then it outrightly becomes a case of defection. And this is the reason that in other democracies there are no such laws of anti-defection, because those democracies work in a different manner in which the people, the legislatures or the ministers are more accountable to the people. Now, if you see the latest case, the most interesting case that happened in India regarding this defection issue was in 2022, I think 2022, 2023, it was a case of Maharashtra crisis. Two crises was there in Maharashtra. One is the Shiv Sena crisis, and thereafter also another political party faced a huge crisis in Maharashtra. Now, what happened that now we have the election results, right? Now the elections have already been done and election results are there, and we can see the how the people voted. So all these technicalities are aside, and the voting behavior or political behavior is a different. So that kind of gives the fuel to the fire of defection. So as per the definition of Subhas Kashyap and also the definition given by the committee based on whose recommendations the anti-defection law was primarily designed, defection always occurs on the cases of personal motive and on the cases of personal favors that one can get from the government. So after the passage of the 170th Law Commission of India reports, the Goswami Committee report, and the review of the working of the Constitution in 2002, there was another amendment, the Constitution 93rd Amendment Act, that comes in 2003, and it removes the provision of split. Under paragraph 3, it removes the provision of split, and also it does an amendment of certain other provisions. And now the present situation is that if earlier what used to happen, that in order to lure the legislatures of opposite party, there was a offer of office of ministerial birth and all that. Now it is clear that up to a certain percentage only you can have your council of ministers, and there is a maximum limit, and there is also a minimum limit in certain cases. So it acts as a check, a constitutional check on the misuse of this power of allocating ministerial responsibilities amongst the legislatures from opposite party. So even after the 93rd Constitutional Amendment Act, now at present we have two dilemmas. If we look at Article 101 or Article 102 of the Constitution that relates to the Parliament, then we have the provision for disqualification. Now, in that provision, the constitutional functionaries that deal with the disqualification are different. Now, the Election Commission had in 2004 given a report that the anti-defection law should also have similar kind of constitutional functionaries, like the president, like the governor. And under the 10th schedule, the constitutional functionaries who decides on the cases of defection are very different, as you know, as Sir has also explained. Those are the parliamentary functionaries, already member of parliament, and they are also dependent on the support of the majority in order to hold their respective offices. So now coming quickly to the legal repercussions of this anti-defection law, there are three areas which are needed to be dealt with when we understand the anti-defection law. First, the speaker's power is not suo motu. The speaker or the chairman or the deciding authority, although the chair acts as a tribunal, and it is presumed that the chair will act impartially in cases of deciding whether there has been defection or not. but it does not act suo motu, right? So when the certain amount of people has elected a legislature, and that legislature, member of parliament or state legislature assembly defected from the original political party. I'm just using the colloquial term original political party. So if if they have defected from that party, and now after that somebody needs to complain to the speaker, they need to raise an objection and put in a formal complaint for the speaker to act. It cannot act suo motu. Now when we talk about this kind of cases, then either the speaker can act under a complaint, obviously, or it cannot, or the speaker is virtually helpless, as no steps can be taken about the defection. Now, what happens when we are having a perspective of voters' accountability over this issue, right? The voters might have a say over whether the legislature did a right thing in defecting, or whether he or she did a bad thing in defecting, right? It is a question of political morality. But the voters does not have any legal recourse in this case. No voter can raise an objection. The people who have voted, actually, they cannot raise an objection. They have nothing to say in this. Now, the second thing is that when we understand defection, in case of the present scenario, we are dealing with we are dealing with a slight of a legal fiction here, as we have seen in the Maharashtra case, as decided by the Supreme Court, that what is the main political party and what is the legislature, the political party functioning in the legislature. So when it comes to certain thin lines of legal fiction, then it is obviously that under the reasonable and to a reasonable person or a reasonable mind, it is very clear that the party which puts up a candidate for the election, and the party which favors a candidate on whose manifesto the candidate get elected, that is the political party. And if we see the present the dilemma between this political, which what is the original political party and what is the legislature party, then the accountability of the legislature party or the accountability of the individual legislatures is to the political party. Because the definition of defection is all about the membership of political party, or not accepting the decision of the whip of the political party, voting against a particular political party. So the accountability is to the political party, and accountability is not to the voters. So here it comes that the right of freedom of speech and expression and the right of political dissent gets really challenged. Now, what about that? If the right of political dissent gets really challenged, then what can we do about it? So obviously, if we now shift our gaze to the decisions of the Indian Supreme Court, then the first case that came around in this regard is Kihoto Holoha versus Rashidu. It is a case of 1992, and in that case itself, in the last few years, when the Manipur crisis occurred, and the Supreme Court has referred to this case also, it's a very landmark case. And in this case, the court took a restrictive view of the direction issued under the meaning of the word direction issued under paragraph 2. The court took a restrictive view in view of the provisions like Article 105 and 194. Article 105 and 194 protects and talks about the freedom of speech and expression of the members of the parliament. So it took the view that only those matters which are integral to the political party, which are very much integral to the political party, and on matters like no confidence motion, there can be we can have a mandatory requirement that a party candidate who has been elected should behave in a particular way. Otherwise, the court also recognized the fact that when the speaker acts as a tribunal and the speaker decides on the cases of disqualification, then the speaker is not always immune from all the vices of human personality that we as a human being face. For example, we will be supporting a political party, we will be getting elected on the votes of certain majority to become a constitutional functionary, and then how can we be how can it be ensured that we are acting on an impartial manner? So this is the case. It was recognized in this the case itself, the balances between the freedom of speech and expression and the dissent. So it was the case of Kihoto Holoha versus Zashidu. After that, what happened that under paragraph 8, the speaker can frame rules. Under other paragraphs, other provisions also, the speaker can frame the rules regarding the defection. So the Supreme Court held that these rules, when we talk about the bar of judicial review, that the speaker's decision has been is final and no court can interfere with the decision. So when we talk about the bar of judicial review, in that same case, the court held that in order to create a limitation on Article 136, 32, or 226, it needs to be amended in a particular way. And since this was not done, so there is not a complete bar on judicial review, and we can, the Supreme Court can interfere in these cases when there is a blatant violation of the principles of natural justice. But when the decision of the speaker is pending, at that time the court cannot enter into the matters of that individual complaint. So as we can see that the court told that if the matter is sub judice, if the matter is under the consideration of the speaker, then the court will not interfere. The court will not be in the position to entertain the petition about the whether it is valid or invalid, whether it is unconstitutional or not. But in the Maharashtra case, we have seen that the court did took a stand when the decision was still pending, kind of. So what happens is that in the political dynamics, in the development of the party system, in the development of the political dynamics, certain things like the issue of defection depends very much on the political morality also, and on the understanding of the constitutional principles as such. So as an impact of as a what coming back to the main topic, that is the impact of 10th schedule on the coalition politics in India. As far as we can say, there is a very reputed author on constitutional law, and he states that only two speakers have been very much impartial and also had the legal acumen to deal with defection proceedings. And rest of the speakers and rest of the constitutional functionaries are not that adept in dealing with the defection proceedings, nor can a brand of impartiality be presumed over any such or every such constitutional functionary. Having said that, I think that at the present time, many political parties, and mostly the news that is being highlighted, all the news that we see, there has been several instances where the political parties has created loopholes in the law, or they have not created, they have looked for the loopholes in the law, and they have become immune to the challenges of defection. As sir has, the last speaker, the respected Vinay sir, has already talked about the Maharashtra case and how the resignations happened and how the real Shiv Sena and the other faction came to be recognized and all this. So mostly the political parties have already started looking for loopholes and has operated through these loopholes. Now what happens is that under such cases there is a term called judicial interference or judicial intervention. So that cannot happen. The positive side will be judicial supremacy. Now, for every action of the parliament, of every action of the speaker, every action of any constitutional functionary, we cannot go to the Supreme Court and move the Supreme Court. So there are certain stages. We can go to the High Court, then we can go to the Supreme Court. Even if we are going to the Supreme Court, it must be a question of fact, basically, interpretation of the rule of the Constitution and all. And we cannot expect the court to administer the country or the court to be the guardian of this kind of parliamentary procedures, because it is a question of constitutional conventions, what we understand as convention, how we behave as individuals. So in this thing, I think that the way forward, the recent cases have been, and all the cases up till now had been, that the 10th schedule has been kind of misused by the political parties, and they have devised ways in which they can avoid the repercussions of 10th schedule. And even if you go into the 10th schedule and there are certain other procedural matters, the court will not interfere. And if there is a blatant violation of natural justice and all such, in that case also the court will be limited in its approach, because in the case of the Maharashtra, the CM resigned before the floor test, right? So it was a political decision. It was a purely political decision, and it is a good decision, given that what the political circumstances was there. But the Supreme Court, even after clarifying the law, even after explaining what is the legal provision, and even after taking a certain kind of stand which is anti-defection, right, and yet could not reinstate the government because there was a voluntary resignation. So in these cases, it will be very much dependent on our political actors to understand this law of defection. And as I have said that in 1985, when this law was passed, there was not even a single opposition vote to this law. At present also, we need some unanimity. in order to make India more stable politically and in order to reap the benefits of our heterogeneous democracy. In this point, I would like to conclude that yes, there is a freedom of speech and expression, and there is a right of political dissent also. And the Supreme Court has recognized that right by giving a restrictive view of the order of the word, the directive issued under paragraph 2 of the 10th schedule. And recently in the Manipur case, and also going by other suggestions given by the election commission and all that, there should be layers of functionaries which can decide the disqualification or defection proceedings. And in this case, the court has suggested, and the court also other various authorities have told about the independent tribunal being headed by some retired justice, which should replace the speaker in these cases of defection. So that's all. I would like to conclude my topic now. If there are any question, we'd be happy if there are any question.
Thank you, Nishit, for your enlightening speech. And you have mentioned judicial observations regarding the anti-defection law. So my question to Dr. Vinay Kumar is, Dr. Vinay, do you think that the anti-defection law is against to true spirit of democracy? Because we are avoiding the people not to defect from one party to another party. So everywhere we are highlighting the concept of democracy, that
Yeah, as I've already emphasized about the same, that for the smooth governance, there is a need for a political unity, and there's a need for the legislatures voting on the party lines. Keeping aside it, which it becomes very difficult to identify whether a person X or Y is acting on selfish interest, or whether he is acting on his conscience for the benefit of the people. So it is quite difficult for us to come to a conclusion on this aspect. But as we discussed earlier, that in case of the defection, no policy can be framed by the government. So this may lead to a chaos in the state. So sometimes for the, as said by the Bentham, that for the largest benefit, greatest happiness of the greatest people, taking it into consideration, it is better that the legislators need to vote on the party lines.
Okay. My question to Mr. Nishit Ranjan Chaki. So you talked about the judicial observations regarding anti-defection law. And do you think that is there any need to amend the 10th schedule of the Constitution to address this kind of defections?
Sir, actually, what happens is that sometimes we obviously we create law out of the present needs. So when in 1985 this law was made, it was suitable for that Indian society when
Okay.
we were ready to fight defection, so that we never had a opposition vote also that time. But after that, if you see the study of the various commissions, like the election commission, I've referred the working review of the working of the constitution, they all have suggested changes in the process. And as of now, if we talk about, then there, as in my personal opinion, there has been a misuse. There has been blatant misuse of this defection, the provisions of defection. And in order to escape from these provisions of defection, only certain, legal schemes have been legal, not legal. Finding the loopholes of the law has been utilized by the political actors. So yes, obviously there is a need for amendment of this 10th schedule. And in order to amend in this 10th schedule, I would like to emphasize that there can be layers of scrutiny. For example, if the speaker is the first body to decide, is the first person to decide on disqualification, there might be a provision of appeal against his decision, and also there should be a time limit. It should be mentioned in the constitution that these are the rights and this is the procedure of inquiry, and this is the time limit within which the speaker should act. The Supreme Court has already emphasized in different cases. So yes, there is a need for this thing, amendment.
Okay, thank you, sir. My last question to Nishit. Nishit, that political parties issues whip. So the whip will have any legal, it is a constitutional, it has any constitutional rights?
Sir, no, sir. Whip does not have any constitutional right. No, it does not have any constitutional provision attached to it. But yes, it is a convention. I think that the process of whip, that we have been taking this parliamentary form of democracy from Britain, and it is a convention that the office of whip exists, and the office of whip has certain amount of authority, and also the
Okay.
official nature of that cannot get disobeyed.
Okay, thank you. Any questions from the participants? Meghana, Somaya, both of them are doing MA Economics at ICFI,
Okay.
and they are there. Just I'm looking at them. That any questions from the participants? If there are no questions, we will conclude. On behalf of the Sakshi Media Group, we are very grateful to Dr. Vinay Kumar and Mr. Nishit Ranjan Chaki for
Thank
their
you, sir.
exceptional contribution to this event. The expertise of both the resource persons. Actually, personally, I am very much satisfied with the performance of these two resource persons.
Thank you, sir.
So we are very greatly, so expertise of these two resource persons greatly enriched the experience of our attendees, and we are truly thankful for the valuable contribution of Dr. K. Vinay Kumar and Mr. Nishit Ranjan Chaki. We are also thankful to the participants for their participation in the webinar. And finally, we are very grateful to Sakshi Media Group for allowing us to conduct this kind of webinars for the sake of benefit of the students and audience and academics also. Thank you very much, Dr. Vinay Kumar and Nishit Ranjan Chaki.
Thank you very
Thank
much,
you.
sir. Thank you for
Thank
the
you, sir.
invitation. Thank you to
Thank you,
the
sir.
Sakshi Media Group for organizing this this program. Thank you very much, sir.
Thank
Looking
you,
forward
Nishit.
to meet you personally whenever I am in Hyderabad.
Thank you, sir. Thank you. I will also invite you both